In Washington, hearings often blend into the background noise of politics, dense, procedural, and quickly forgotten. But every so often, a single exchange cuts through the fog, commanding national attention. That is exactly what happened when Senator Jeff Merkley confronted Kash Patel in a moment that will be remembered less for policy detail and more for a blunt question that echoed across media headlines. Have you even read the Constitution? The remark was more than sharp rhetoric. It was a distillation of growing concerns about how public officials approach the very foundation of American governance. Merkley's choice to challenge Patel on constitutional literacy was deliberate. He framed the issue not as a partisan clash, but as a matter of civic accountability. In doing so, he elevated the exchange from a personal critique to a test of public service itself. Patel's responses, hesitant and evasive, only deepened the impact. By disclaiming expertise and suggesting that certain constitutional obligations were not his responsibility, he invited scrutiny that stretched well beyond the walls of the hearing chamber. Merkley seized the opportunity to press home a larger point. The Constitution is not optional reading, and its protections are not subject to selective interpretation. The hearing offered more than a clash of personalities. It offered a window into the fragile balance between political authority and constitutional duty. Merkley's interrogation underscored a fundamental reality that public trust depends on the visible, consistent commitment of officials to uphold the nation's founding principles. Anything less risks eroding the very legitimacy of governance. What unfolded over the course of this exchange was not simply a tense dialogue, but a sequence of reminders, challenges, and revelations. Each one pulled into focus the tension between constitutional clarity and political evasion. From the universal guarantee of due process to the oath sworn by every official, Merkley methodically dismantled the idea that constitutional obligations can be treated as flexible. In this breakdown, we'll examine 8 key facts that emerged from this hearing. Each reveals not only the weight of Merkley's critique, but also the broader lesson for governance, accountability, and the durability of constitutional standards in turbulent times. And it all begins with the question that framed the entire exchange, the core zinger that set the tone for everything that followed. In a Senate hearing that will likely be replayed across news networks and political podcasts for weeks, Senator Jeff Merkley delivered a striking rebuke to Kash Patel, a senior figure tasked with oversight and enforcement responsibilities. At the heart of this exchange was one searing question, delivered with surgical precision. Have you even read the Constitution? This was not a rhetorical flourish meant to score quick headlines. It was a deliberate attempt to underscore a deeper concern, that an official entrusted with critical authority appeared uncertain or perhaps dismissive of the very document that guides the rule of law in the United States. Merkley's framing cut directly to the core of public confidence in governance. After all, what does it mean for an individual to hold office, wield influence, and speak on matters of justice and due process while seeming to falter on the most foundational text of American democracy? The exchange gained traction not only because of its bluntness, but because it crystallized a growing unease. In today's polarized climate, the Constitution often functions less as a shared text of governance and more as a battleground of interpretation. Merkley's words exposed the fragility of that balance, putting Patel on the defensive in real time. His question implied more than ignorance. It suggested an unwillingness to fully embrace the responsibilities of office. Observers noted that Merkley's line resonated with the public precisely because it was plain spoken. While hearings are often cluttered with jargon and evasions, his phrasing cut through the noise. The Constitution is not optional reading. It is the guiding standard for every policy decision,
every enforcement action, and every public responsibility. To imply unfamiliarity is to invite doubt about both competence and commitment. And that is where Merkley struck a chord. By asking Patel if he had read the Constitution, he was in effect asking whether Patel could be trusted to uphold it. That single question reframed the hearing from a policy discussion into a moral and civic examination. But Merkley did not stop with that piercing question. He followed it with a reminder that cuts to the heart of democratic principle. Due process is not a privilege. It is a guarantee for all. And that brings us to fact 2. Following his initial rebuke, Senator Merkley shifted the focus of the exchange to one of the most essential pillars of American democracy: due process. His reminder was pointed and precise. The Constitution does not offer selective protections. It does not carve out exceptions for convenience or political preference. Instead, it affirms that due process is a right guaranteed to all persons within the jurisdiction of the United States. This clarification was more than a matter of legal theory. In the context of the hearing, Merkley emphasized that Patel's framing, suggesting that some individuals might not be entitled to these protections, posed a direct threat to constitutional consistency. By highlighting the phrase, all persons, Merkley underscored that the Constitution makes no distinction between citizens and non-citizens when it comes to fundamental legal protections. This is not a matter of interpretation. It is written into the text itself. The implications are profound. In practice, due process ensures that the government cannot arbitrarily detain, punish, or remove individuals without following lawful procedures. It is the backbone of fairness in American law. Stripping that guarantee away from certain groups creates not only a legal contradiction, but also a dangerous precedent. If the rights of one group can be suspended, then the protections of all are weakened. Merkley's statement carried urgency. At a time when debates over immigration, detention, and security are politically charged, the reassurance that the Constitution's protections apply universally serves as a guardrail against overreach. His insistence was not merely about holding Patel accountable, it was about reaffirming that the Constitution is designed to withstand political turbulence by maintaining consistency in its promises. In the room, this point created tension. Patel's responses appeared evasive, further intensifying Merkley's critique. His insistence left little room for ambiguity. Due process is not conditional. It is universal. If the principle of due process is universal, then ignorance cannot be an excuse. Yet Patel's own words suggested a troubling admission, that he may not even see himself as accountable to constitutional standards. And that leads us directly to fact 3.
As the exchange deepened, Kash Patel attempted to shield himself from Senator Merkley's pointed questions with a phrase that has since echoed far beyond the hearing: "I'm not a constitutional scholar." On the surface, it may have sounded like humility, a candid acknowledgement that he did not hold advanced academic expertise. But in the charged atmosphere of the Senate, those words carried an entirely different weight. Merkley was not asking Patel to perform scholarly analysis or cite obscure legal cases. He was demanding assurance that a senior official entrusted with upholding the law understood the fundamental principles of the nation's guiding document. By disclaiming expertise in this way, Patel inadvertently revealed a troubling gap, not in academic training, but in constitutional literacy. To the public, the optics were unmistakable. If a high-ranking official admits ignorance of the basics, how can citizens trust his judgment on matters that affect their rights? In today's political landscape, officials are frequently challenged on their interpretations of constitutional provisions, but seldom does one step back so far as to suggest that knowledge of the text itself may be outside their grasp. This was not humility, it was a warning flag. For an official to openly state a lack of grounding in the Constitution suggests that decision-making may lean more on political expedience than on constitutional responsibility. Merkley seized upon this moment, pressing the issue with precision. His retort that Patel had not even read the Constitution was not only rhetorical but symbolic. It reinforced the idea that public office demands more than a title. It requires commitment to the text and principles that define governance in America.
This exchange illustrated the risks of hiding behind disclaimers. What might sound like modesty in casual conversation becomes a revelation of unpreparedness in the halls of government. And while Patel's claim of not being a scholar raised eyebrows, Merkley's next move sharpened the focus even further. He brought the discussion back to the very text itself, and with it, the question of whether loopholes can ever exist in constitutional language. That brings us to fact 4. When Senator Merkley directed the conversation back to the constitutional text itself, his strategy became clear. He emphasized the clause that has withstood centuries of legal scrutiny: all persons. By doing so, Merkley placed the spotlight on a fundamental truth. Constitutional protections are written in language that is both deliberate and unambiguous. The Constitution does not say some persons or citizens only. It says all persons. This was more than wordplay. Merkley's point carried weight precisely because attempts to carve exceptions into this language have been used throughout history to justify inequality, discrimination, and selective enforcement. By reiterating the clarity of the text, he dismantled any argument suggesting that constitutional protections are subject to personal or political interpretation. The words are plain, and they are meant to apply universally. Patel's reluctance to affirm this principle revealed an unsettling reality. When public officials hesitate to acknowledge protections that are clearly written, it signals not just misunderstanding, but also the risk of selective governance. The Constitution is designed to bind government actors, ensuring that individual rights are not compromised by shifting political winds. Ignoring or narrowing the meaning of all persons undermines that very safeguard. Legal experts following the exchange noted that Merkley's insistence mirrored judicial precedent. Time and again, courts have upheld that due process protections extend to all individuals on U.S. soil, regardless of citizenship status. By pressing Patel, Merkley was not merely engaging in debate, he was holding a senior official accountable to established constitutional law. The hearing room grew tense as Merkley repeated his point. His persistence left Patel with little room to maneuver. Each evasion only reinforced the perception that the official sought to blur a line that the Constitution makes unmistakably clear. And while Merkley underscored the clarity of all persons, he didn't stop there. He reminded Patel and the public that this wasn't just theory. It was about oaths, promises, and the responsibilities sworn by every official. That's where Fact 5 comes in.
At this stage of the exchange, Senator Merkley widened the frame. His reminder was direct. Kash Patel, like every public servant in government, had sworn an oath to uphold and defend the Constitution of the United States. That oath is not ceremonial filler or a formality to check off on day one of the job. It is a binding promise that underscores the responsibilities of public office. Merkley's insistence on this point struck at the heart of public trust. Citizens expect their officials not only to understand the Constitution, but also to actively defend it against encroachments, whether foreign or domestic, intentional or negligent. Patel's hesitance in affirming due process for all persons appeared to place political calculation above constitutional commitment, and Merkley wasted no time in drawing that contrast. The senator reminded the chamber, and by extension the nation, that selective interpretation of constitutional guarantees erodes the very foundation of governance. An oath does not permit cherry-picking. Officials cannot swear allegiance to the Constitution and then sidestep its provisions when inconvenient. Doing so undermines the integrity of government and raises serious questions about accountability. Observers noted the symbolic weight of Merkley's approach. By invoking the oath, he framed the debate not as a partisan clash, but as a matter of civic integrity. The Constitution is the standard to which all officials must answer, regardless of ideology or political circumstance. Patel's apparent unwillingness to stand firmly on that standard raised doubts about his priorities. Was he guided by principle or by politics? The power of Merkley's reminder lay in its simplicity. Public office is not about wielding authority. It is about stewarding trust. And the Constitution, as the foundation of that trust,
demands fidelity from those who serve under its protection. Yet as Merkley pressed for accountability, Patel attempted to retreat behind another shield, claiming it was not his role to intervene in certain matters. That deflection set the stage for one of the hearing's most telling exchanges, which brings us to Fact 6. When pressed further by Senator Merkley about constitutional guarantees, Kash Patel responded with a phrase that seemed rehearsed, yet carried heavy consequences. "It's not for me to call balls and strikes." On the surface, this language attempted to frame Patel as a neutral participant, someone standing back from constitutional interpretation and leaving judgments to others. But in the hearing room, it landed as a glaring abdication of responsibility. For an official charged with oversight, law enforcement, or decision-making authority, neutrality cannot extend to ignoring constitutional obligations. The phrase suggested that Patel saw his role as limited, almost spectator-like, in matters where rights and protections were potentially being violated. To Merkley and to many observers, this was unacceptable. Public officials cannot step aside when fundamental rights are in question. To do so is not impartiality, it is neglect. Merkley seized the moment to emphasize the danger of such deflections. By portraying himself as someone who simply calls plays made by others, Patel implied a willingness to act without accountability. Yet accountability is at the heart of public service. If officials refuse to engage when constitutional issues arise, who then safeguards the public? Legal analysts pointed out that this kind of rhetoric often surfaces in hearings when officials want to avoid committing themselves. But the stakes here were higher. Patel was not being asked for a personal opinion, he was being pressed on whether he recognized the constitutional duty to ensure due process for all persons. His refusal to step into that role raised doubts about the very purpose of his position. Merkley's pointed questioning revealed the flaw in Patel's stance. The Constitution is not a game, and public service is not a spectator sport. By dodging responsibility, Patel highlighted precisely why oversight and accountability remain essential in governance. And just when it seemed Patel might find cover in ambiguity, Merkley turned back to the document itself. With the words of the Constitution in hand, he underscored a truth that left little room for spin. That takes us to Fact 7.
As the hearing pressed forward, Senator Merkley returned to the foundation of his critique, the plain text of the Constitution. Holding firm, he reminded Kash Patel that constitutional protections are not abstract, obscure, or buried in complex interpretations. They're written in language accessible to every official, every citizen, and every resident. The clause at issue, all persons, was not hidden in footnotes or cloaked in ambiguity. It was plain, deliberate, and central. Merkley's strategy was calculated. By pointing to the simplicity of the language, he eliminated the possibility of spin. Patel could not argue nuance or claim technical confusion. The Constitution was clear, and its clarity was meant to serve as a safeguard against exactly the kind of selective enforcement that Merkley accused him of tolerating. In a political environment where officials often rely on jargon, evasions, or partisan framing, Merkley's insistence on reading the text aloud was striking. It cut through the fog of political discourse and placed the spotlight directly on Patel's reluctance to affirm a straightforward principle. To the public, this exchange reinforced the perception that Patel's position was not constrained by ignorance, but shaped by choice, an unwillingness to embrace constitutional universality when it conflicted with political objectives. Legal scholars observing the moment noted that Merkley's approach mirrored courtroom strategy. When a witness resists answering directly, attorneys often turn to the written word, asking them to read it aloud. The act forces accountability, making evasion more difficult. Merkley's repetition of "read it because it's plain" worked in the same way, pressing Patel into a corner where his reluctance became more visible. The symbolism was powerful. The Constitution was not presented as an academic puzzle, but as an open book.
Patel's hesitance to align with its plain meaning amplified Merkley's broader warning: constitutional fidelity cannot be optional. And with the words themselves laid bare, Merkley's final move was not about one official, but about the larger principle. His closing message transformed the hearing from an exchange into a lesson on governance. That leads us to fact 8. As the exchange drew to a close, Senator Merkley left the chamber and the audience with a message that transcended the immediate clash. His words carried the weight of a reminder. The Constitution is not a set of suggestions, nor is it a document to be selectively applied depending on circumstance or political preference. It is a binding standard, an unchanging measure against which the actions of every official must be judged. By holding Patel accountable to the text, Merkley underscored a fundamental truth about governance. Officials may come and go, policies may rise and fall, but the Constitution remains the anchor. Its protections are not conditional, its promises are not negotiable, and its authority does not diminish in the face of political expedience. The moment a public servant attempts to reduce those protections to options rather than obligations, the stability of democratic governance is at risk. Merkley's closing observations reframed the hearing into a broader lesson on civic responsibility. His confrontation was not aimed only at Patel, but also at the institution of public service itself. The hearing served as a reminder that fidelity to the Constitution is not symbolic, it is the very foundation of legitimacy in public office. For citizens watching, the takeaway was equally clear. Vigilance is required. Democracy endures not because officials claim loyalty to the Constitution, but because they are held accountable to live by it. Commentators noted that Merkley's remarks drew on a larger tradition of Senate oversight, one that emphasizes the duty of elected officials to demand clarity and consistency from those entrusted with power. By reasserting that the Constitution is a standard, Merkley reinforced the principle that officials cannot choose convenience over commitment. In essence, his final message turned a tense hearing into a civic reminder. The Constitution is not a tool, it is the rule. And with that, Merkley closed the book on Patel's evasions, but opened a much larger discussion. The hearing ended, yet the questions it raised remain alive. How should citizens respond when officials treat the Constitution as optional? That's where our conclusion comes in.
As the hearing concluded, the immediate headlines focused on Senator Jeff Merkley's piercing question, "Have you even read the Constitution?" But the larger story lingers far beyond a soundbite. What unfolded in that chamber was not simply a clash of words between a senator and a senior official, it was a public test of principle. A reminder that the Constitution is more than a document displayed in classrooms or recited in ceremonies. It is the binding standard that legitimizes every action taken by those in government. Merkley's approach highlighted something too often overlooked in political discourse. When officials appear willing to narrow constitutional protections, or when they evade accountability by minimizing their responsibility, they are not merely engaging in politics. They are eroding the very foundation of democratic governance. His insistence that due process applies to all persons served as a reminder that rights are only as strong as the willingness of leaders to defend them. The tension revealed in Patel's responses underscores why public oversight matters. Elected officials carry the duty of pressing, probing, and holding to account those who wield power. Without that oversight, evasions can harden into precedent, and precedent can reshape rights. Merkley's interrogation demonstrated that one voice, armed with the text of the Constitution, can cut through layers of ambiguity and restore focus to the principle at hand. For citizens, the lesson is equally clear. Democracy does not function on autopilot. It requires vigilance, engagement, and the expectation that officials will uphold the standards they swear to defend. The Constitution is not a suggestion. It is the measure against which every policy, every enforcement action, and every decision must be judged. This exchange was more than a moment of political theater. It was a reminder of civic duty, both for those in office and those watching. As viewers, as voters, as participants in the democratic process, the responsibility extends to us as well. Stay engaged, ask questions, hold officials accountable. If this breakdown sharpened your perspective, subscribe to @GlobalPulse_NRZ for more in-depth analysis of politics, power, and principle. Share your thoughts below, because democracy is strongest when citizens demand clarity, demand accountability, and demand fidelity to the Constitution.